Good evening, everyone, and thank you for attending our event this evening, our VIP Estate and Legacy Learning event here with our experts that we've brought in. Today is not meant to be an estate planning 101 session. Most people and our clients in this room, already understand the importance of having a will, powers of attorney, beneficiaries, and really the right advisor around the table. What we want to talk about tonight is something a little bit different. Are the pieces actually aligned? Because in practice, the risk is often not that the document is missing. The risk is that legal plan, tax plan, investment plan, insurance, corporate structure, and family intentions were all created at different times, often with different people and for different reasons.
And that's where we see things quietly break down. Someone might have a will, but their beneficiary designations might tell a different story. A corporation might hold a major part of the family wealth, but the personal estate plan doesn't fully account for it. A child might be named executor because they are trusted, but no one is really asked whether they are prepared for the job.
So today, really, John and I want to help frame the planning issues we see from the wealth management side. And we are fortunate to have Samantha Russell from Solace Trust and Alexandra Drab from Darnell Law Group with us to bring deeper trust, estate administration, and their legal perspective.
Thank you both for joining us today. Our goal is simple. We want this to be practical. By the end, we hope you are thinking less about whether you have the documents and whether your plan would actually work the way you intend when it matters.
Let's get into it. Maybe a good place to start is with the idea that most plans look complete on paper. Alexandra, maybe we'll start with you. From a legal perspective, when you see families and high net worth clients really come in with, wills, power of attorneys, and other documents already in place, whether it's recent or in the past, where do you often see things that start to drift or become outdated?
Yes, so I think where things become outdated is when major life events happen and major changes occur, such as a marriage or separation or divorce, the birth of children, grandchildren, retirement, or purchase of new assets. And just there's so many exciting things that are happening at that point that the estate plan kind of forgets to be updated and changed, and that's where it becomes problematic. And it might not reflect your true wishes for your current life circumstances. And so we typically recommend that you review your estate plan every 5 to 7 years. That doesn't mean you necessarily have to redo the documents every 5 to 7 years, but at least you're just reviewing it to make sure it's currently makes sense.
Samantha, from the trust and estate administration side, you often see what happens after someone's passed away or when capacity becomes an issue. What are some of the gaps that families do not realize until someone actually has to act?
Yeah, so I think what tends to surprise families most is how administrative, slow, and emotionally demanding estate and trust administration can be in real life. So even when there's a valid will, capable advisors, and generally sort of cooperative beneficiaries, the process can still take a year and a half to 2 years to wind up the estate, and that's if things are going well. So families are often surprised just by the sheer volume of work involved. So locating and valuing assets, dealing with financial institutions, preparing tax filings, addressing potential creditor issues, managing property, communicating with beneficiaries throughout the entire process so that they're up to date. And I think people often also underestimate how quickly stress can turn into distrust if communication is inconsistent or expectations were never clearly set during the sort of deceased person's lifetime. So I've seen a lot of estates where initially the family believed the administration would be really straightforward because there was a will and there was no obvious dispute, but in practice, the executor still had to deal with multiple bank accounts, a holding company, private investments, two properties, and significant sort of tax reporting obligations. So, what the family expected to take a few months ended up taking much, much longer, not because anyone had done anything wrong, just simply because the work itself was more involved than they had imagined.
Yeah, and one of the points we wanted to make tonight is that being named an executor is not just an honor, it's a job. I think a lot of people choose an executor because they trust the person, which makes sense. You know, they have to get into your passwords and your email and everything like that. But trust is only one part of it. The role can always involve lawyers, accountants, trustees, financial institutions, tax filings, asset valuations, beneficiaries, deadlines, all sorts of estate accounting that you have to do, and sometimes some very difficult financial or family discussions. So, Alexandra, maybe you can explain what an executor actually is responsible for once someone passes away.
Of course. So, at its core, an executor's main responsibility is carrying out the wishes of the deceased person. And as you mentioned, it's a very important role. It's extremely time consuming and stressful. And we always kind of make a joke here that you basically will only be an executor once in your lifetime because you will never take on that responsibility again after knowing what's involved. So, the executor has to manage the funeral arrangements, must locate the will, start that initial probate process, which again involves a whole team of people from your lawyers to your accountants to a trustee, if that's relevant. They also have to secure the assets. So this is especially true with real property. So you have to go in there, make sure that none of the beneficiaries or anybody else has access to that property and can take things without having the right to take it. They will also be responsible for things like securing the debts and liabilities and making sure that those are all paid for, the final income tax, and then, of course, distributing the assets. As Samantha kind of touched upon before, I think a lot of the breakdown that kind of happens occurs when the beneficiaries underestimate the amount of work that goes into being an executor and the time that it'll take. A lot of times we have executors come in talking about the beneficiaries, pressuring them to make those distributions, and really they can't do any of that until the grant of probate's done. There's a clearance certificate from the CRA. So really, I think that's where a lot of the stress and burden comes in, is when the beneficiaries are just underestimating the amount of work it takes to be an executor.
Yeah, and just maybe you can just touch base too, because yes, we have many clients who have helped settle, been executors, been in that role, but for some people who haven't yet, maybe or are new to the process, or maybe have elderly parents, or will come into some sort of situation, maybe just can you explain like the timeline too? Because again, some people might be like, oh, probate might take a month, and then they can pay out the beneficiaries. Maybe just give a clear picture of what that timeline can look like.
Yes, of course. So it will, of course, vary from province to province. But for instance, in British Columbia, where I'm based, you're probably looking about 6 months to even getting the grant of probate. And then from there, and that's dependent on whether or not the assets are clearly lined out. They can find everything, they can account for everything. And then from there, it can still take a year to maybe even 2 years to make those final distributions and get that clearance certificate from the CRA as well.
Yeah, great. Good insight.
And one thing to add to that is that also involves multiple tax returns, because if you're going over calendar years and you still have assets in the estate, you're going to have to do a tax return for every year that you've got it before you can actually get that clearance certificate.
And Samantha, we'll pivot a little bit to you. When does it make sense, do you think, to add a professional support maybe, or a corporate executor, or even a co-executor arrangement, maybe some situations that you've seen?
Yeah, so I think families should consider professional executor or trustee support. For example, when the estate is complex, valuable, long-term, or emotionally sensitive. So really that covers a whole range of different circumstances. And professional support is particularly helpful when the estate includes private corporations, real estate across jurisdictions, discretionary trust, blended family issues. So that's when we've got sort of multiple marriages and children from previous marriages that are involved, when you've got vulnerable beneficiaries. So, beneficiaries with special needs or a disability, or beneficiaries who do not get along. And it's also worth considering where the proposed family executor is simply like whether they're in a position to dedicate the time and attention required. I think oftentimes we have someone we trust, but sort of what stage in life are they at, right? Like, do they have a busy career? Do they have young kids? Do they have time to step in and take on this role? So, for example, in a situation where an adult child had been named executor because they were organized and trusted by the parent, oftentimes, sometimes the eldest sibling, the estate, so, it included one example I'm thinking of, it included an active business, investment accounts, and siblings with like very different expectations with respect to each of those assets. So, what began as kind of a gesture of good faith and trust quickly became a source of sort of personal strain, not only for the person appointed as executor, but the other siblings as well. So that executor, found themselves having to make decisions that affected the sibling relationship, sort of answering constant questions and managing like sort of technical issues that they weren't really trained to manage, right? Because really you're stepping into a job that you don't know how to do. And as Alexandra said, you're probably only going to do it once. So in that case, a professional executor or trustee who does this often all the time would have sort of the you reduce both the emotional pressure and the risk involved. So, in many cases, professional involvement, it does not mean removing the family entirely by any means. It often means, having family members either work with a corporate trustee or sort of developing relationships with that entity, just so that the administration benefits from, both the personal context and technical expertise that the professional trustee can provide.
Yeah, and one other one that we see too a lot, especially this day and age with, generation 2 or 3 is location, right? If the estate or the person that passes in BC, kids in Toronto, other kids in the US, trying to navigate that, flying back and forth, going to the bank, meeting with the lawyers, going to the house. That's a lot of time, money, energy, everything. So really, a value add can be from having someone, boots on the ground help in those situations. And one other comment I wanted to make about the executor, and something that John and I always recommend as well, is a lot of people, as you mentioned, Samantha, use their children, and there can be pros and cons to that, but odd numbers we usually recommend, right? So 1 or 3 ideally, because if you're choosing 2 and you have 2 kids, you can come into decision-making lock where one wants one thing and one wants the other thing. And again, a professional can come in and make unbiased decisions based on, clearly what the person that passed wanted. So I do think that that is important. And again, as co-executors, both people have to sign. So, there's that as well. So one thing that we'll look at is how assets are passed and how they're actually passed. So a will is obviously very important, and there's still a lot of Canadians who don't have them, and we stress this with our clients. We review it every meeting with them to make sure they have wills, power of attorneys, all their estate docs, or if they need updating. But one of the key messages tonight is that a will may only control part of the family's wealth, right? Assets can pass through the state by beneficiary designation in registered accounts, by joint ownership, through corporations or trust, by contract, or even through insurance proceeds. So there are other ways that assets can be passed down outside of the will that need to be taken into consideration as well.
And this is where alignment really matters. We'll touch on joint ownership, which is well used. And you can have a well-written will, but if a registered account or insurance policy has an outdated beneficiary, the result can be very different from what the family intended. Alexandra, maybe you can speak on the legal side of joint ownership and why it can be more complicated than people think.
Yes, and this is a hotly debated topic within the legal system, is whether or not it's really worth to have your children added on to your assets as what's a joint owner, specifically a joint tenancy, which means that you both own the property through together, but upon the first of you to pass, that property would then transfer directly to the survivor through what's called the right of survivorship. And so many times people are doing this to try to avoid probate fees, which again in BC is about 1.4%. So it can add up for sure, but it's also whether or not that's worth it. All of this effort is worth saving that 1.4% is a bit of a question. So firstly, when you're dealing with this issue, you have to make sure that if you're adding a child on to a real property, you must check with your financial institution if you have a mortgage, whether or not you're even permitted to add that child onto your property. This is because the property, if you do so, you may be in breach of your mortgage terms, and that could actually end in your mortgage being in default. So it's very, very important to check and make sure that's all accounted for. Secondly, if you're going to go this route and it makes sense for you, you have to make sure that you have the right documentation in place. In Canada, there's a presumption that if a child is registered on an account or the property belongs to a parent, the child does not outwardly own the property, but is holding that asset in trust for the benefit of that parent. So that means that upon the death of that parent, that child does not become entitled to that asset or property, but is actually holding the property in trust for the benefit of that estate. So this would mean that technically, the asset could still end up being subject to probate fees and have to go through the probate process, and it would still be divided pursuant to the will. So if you want to gift that property to one child and avoid probate fees, a lawyer can prepare a document such as a deed of gift with the right of survivorship or bare trust that will clearly outline your wishes and make sure that the child is the true owner after your passing. There's also some additional risks with adding a child onto an asset as a joint tenant. And that includes if your child is in financial difficulties, it is possible that a creditor could come after their portion of your own asset. And your child may also be able to dispose of a property or get a line of credit registered against the property. So it's very, very important to make sure that everything is accounted for. And finally, if your child becomes separated or divorced and enters into a family law proceeding, that child's spouse could possibly try to come after that property or asset. So if you are thinking about going this route, it's very, very important to speak to your whole team of estate planning experts, I guess, for lack of a better word, just to make sure that everything is taken care of and is properly put in place.
And we see a lot of the time in joint ownership, is often used to avoid having any estate assets, right? If everything is joint, one flows from one person to the other person. That's what we typically see. But on an administration side, Samantha, what happens when assets pass outside the estate, but taxes or expenses remain inside the estate?
Yeah, so this is one of the most common sources of, let's say, unfairness in estate planning. So problems typically arise when assets pass outside the estate. So, for example, through joint ownership or beneficiary designations, but the estate is the one that remains responsible for the taxes, debts, and administrative expenses. So the legal transfer of the asset may occur outside the will, but the tax consequences at death may still arrive in sort of the estate or the deceased terminal tax return, and otherwise sort of create obligations that must be funded somehow. So if the estate bears those costs while another beneficiary receives a significant asset directly without having to bear any of those costs, the overall result may be very different from what the deceased person intended. So a common example is where one child receives like a registered plan or a jointly held account directly. And then let's say the residue of the estate passes to the other children. So on paper, the parents may have thought that they were treating the children fairly, but in practice, the estate may have to use its own assets to sort of fund the taxes and the administrative costs, effectively reducing those sort of residuary beneficiaries' inheritance, while the direct recipient receives their share intact. So this is where alignment really, really matters. Like estate planning, it's not just about where the assets go, it's also about who ultimately bears sort of the economic burden of whatever plan you've created.
And I think beneficiary designations are one of those things that can feel administrative when you're doing them. A name gets added to a form, and then you never look at it again. It doesn't show up on any statements. Years can pass by, life changes, no one revisits it. And people don't realize that the designation can override what people assume their will is doing. Their will might say the RSP goes to one person, but if the RSP has a designation, it gets given away first. So, Alexandra, what should families be watching for with beneficiary designations?
So with your beneficiary designations, it's extremely important because, as you said, the designations take precedence over what is in a will. So the important lesson to take away from this is make sure that you are reviewing those appointed beneficiaries every time that you update your will or review your will or your estate plan in general, just to make sure that they all are in alignment and they're actually going to who you want those assets to go to.
Yeah, and I think, or Samantha, when beneficiaries receive assets directly, what do you think that means from or for the estate administration?
Yeah, so from an administrative perspective, I think it can create some fragmentation and confusion and tension, particularly if there hasn't been any conversation about this in advance of that person's passing. So, the executor may be responsible for winding up the estate, but they might not have control over all of the assets connected to the deceased overall wealth. So it can create some practical problems. So it can be harder to sort of assess fairness across beneficiaries. It can be difficult to explain why some beneficiaries receive assets immediately, right? So by way of beneficiary designation, you're receiving those assets right away. And then residuary beneficiaries aren't receiving those assets sometimes for years, depending on how the administration is going. So it can also create some liquidity issues. So if the estate remains responsible for debts, taxes, or costs, as I mentioned earlier, but doesn't have access to the assets that passed outside of the estate, that can also create some tension. So, like, for example, I've seen situations where a principal residence passed outside the estate while the estate itself had investment assets in cash. So the beneficiaries who received sort of the non-estate assets, the principal residents in this sort of example, felt like they had received what they were entitled to and didn't understand why the executor was so focused on, paying the taxes and those costs. Meanwhile, the residuary beneficiaries felt like they were kind of subsidizing the overall administration of the estate. So although the planning may have appeared sort of efficient at first glance, the administration just got, the perception was that it was a little bit unfair and it strained the family relationships a little bit, which is the opposite, I'm sure, of what the deceased person intended in that situation. So I think like direct, designations and joint ownership can simplify matters sometimes. It's just important to think about like the siloed outcomes that you might create in the actual administration of the estate.
Yeah, and everyone sets theirs up differently, and it's all case by case, family by family. But that is a great point. If you name, one child as the TFSA beneficiary, and the other children or child gets money through the estate, someone could be getting paid in 1 to 2 months, while the other ones, could take 6 to 8 a year before they get their payout. So, definitely something to consider. One thing that we often see a lot with our families, and a lot of blended families are a good example of this, is where good intentions can still create tension too, right? A person may want to provide for a spouse and also protect their children from maybe a prior relationship. And those are both reasonable goals, but they are not always solved by simply leaving everything outright. So, Alexandra, what are some of the legal planning tools that help balance those interests?
For sure. So, as we were talking about before, having your designated beneficiaries appointed on your registered accounts is definitely a way to make sure that the distribution in for blended families is as you wish it to be. So, in different provinces, there are what's called the laws of intestacy. That's when you die without a will, and they will dictate how everything is divided upon a passing. And in British Columbia, for instance, if there is no will, the surviving spouse receives $150,000 off the top of the estate, and everything else is divided amongst children and that spouse. So it's important to make sure that you have the estate plan in place to ensure that you are able to have your wishes followed as you want, have your wishes followed as you wish it to be, and so that the laws don't take over. Another great way to make sure that happens is you can put those assets into what's called a life estate, into your actual will or your estate planning documents. And that just means that your spouse will use the property for the duration of their lifetime. And then upon the death of that second spouse, the asset could then be transferred to a second beneficiary, such as the children. So they're not owning that property, but simply living in it, using it for the duration of their lifetime. We also see quite frequently as well that the use of trusts. So to have all of the assets transferred into a trust and have that breakdown for the kids, and having the spouse have certain assets that they want as well. The benefit for that is in British Columbia, of course, we have the will's variation clause where that spouse or child can challenge the will if they do not believe that they are adequately being provided for. And so by having those funds put into a trust, the will's variation laws aren't applicable and they can't be challenged. So it makes sure to ensure that your wishes are actually going to be followed and will not be varied by a court. Yeah, so I think those are kind of the main ways that things can be done. But of course, if you speak to your estate planning professional, that way they can make a plan that actually helps to make sure that your wishes are followed.
That's a good point. And on the trust side, Samantha, another area that surprises some people is the fact that if assets are left to minor children, they know that they go in trust automatically, but they might not realize that they get full access at the age of 18 or come much earlier than intended. Maybe you can talk about staged access or trustee discretion and how that can help.
Yeah, so I think a trust structure is often more appropriate beyond the age of like 19, for example, in BC, and of course jurisdictions depends on the age of majority, but 18 or 19, because that age doesn't necessarily equate to financial readiness. I know at 19, if I received a huge lump sum of money, I wouldn't be like very financially savvy with it. So in BC, for example, when a beneficiary reaches age of majority, they're generally legally entitled to take control of those assets unless there is sort of a staged trust structure in place. But many families are understandably like uncomfortable with that significant wealth becoming fully accessible at age 19. So you can sort of set up a trust where, let's say, those funds are held in trust for a beneficiary and they receive sort of a quarter of the capital at 25, half the remainder of capital at 30, and the full remainder at 35. But it's not that those funds are not accessible during that time. So the trustee would still have the ability to encroach on the capital for the beneficiary's sort of maintenance, education, or benefit, which are intentionally very broad terms. So the trustee really has the ability to still take care of that beneficiary while ensuring that that beneficiary doesn't use up all of the funds more quickly than we would have liked them to, than the deceased person would have intended for them to use those funds.
Okay. And corporate assets and multiple wills, business owners and incorporated professionals, the estate plan needs to look at those through another lens. And a lot of wealth can sit inside of an operating company, a holdco, professional corp, family trust, the corporate investment account. And the question becomes, who owns the shares? Who controls the company? Where does the liquidity come from? We see this a lot when you do estate freezes and the parents have already shifted over the common shares and they forget that they don't actually own it anymore. And I know this is really complex, so maybe we'll just touch on it high level because every case is different. But Alexandra, what do you see or where do you see corporate assets complicating the personal estate plan?
Of course. So as you mentioned, estate freezes are often a tool that is used to make sure that corporate assets are passed through an estate with being mindful of the capital gains taxes and any sort of other probate fees that are applicable in each province. But business owning families should also look at their share structure and see whether it would make sense to have those shares owned jointly as joint tenants between spouses. And so then when one spouse passes, the other asset automatically passes to the surviving spouse without the need of probate or paying probate fees. Of course, there are still those risks that we previously talked about having joint tenancy and joint assets, but this may be applicable to some people. Another really common way is having the dual wills in situations. So one will is for you and your personal assets, while the other will specifically is limited to your assets in your corporation. And so what that allows for you to do is transfer those shares right away without having to go through that probate process for those corporate assets. And so it allows the continuity of those your corporation to kind of work, and without having to wait for those months with share transfer before being able to transfer those shares over.
Yeah, and that's something we always recommend to a lot of our business owners or clients with corporations is always to have, two wills, dual wills, one for personal and one for corporate there. So we're certainly agreed and aligned on there. And Samantha, when a family trust, a lot of people talk about trusts and family trusts or even corporate structures are involved. How does that change the administration picture for an estate?
So families should understand that where corporate assets or trusts are involved, the executor or trustee role becomes significantly more sophisticated. So the fiduciary is no longer just gathering bank account information and distributing the residue of the estate to beneficiaries. They may be stepping into the oversight of a business, supervising management, preserving sort of enterprise value, and making strategic decisions that affect employees, family members, and beneficiaries. So this requires a level of comfort with governance, valuation, legal advice, accounting, and tax coordination. And it's a very different role from serving as executor of a simple estate. So one type of scenario that's not uncommon is that the deceased person sort of held shares of a family company and the children did not all participate in the business. So the executor then had to determine how to preserve value, whether to continue running the business or sell the business, how to treat active versus sort of inactive family members fairly, and how to manage tax deadlines that affected sort of post-mortem tax planning. So it's not simply an administrative exercise at this point. It's very much a fiduciary role with real commercial consequences. So where ongoing trusts are involved, the trustees also need to understand that they're going to be making sort of discretionary decisions for years, sometimes decades, depending on the nature of the trust and when the deceased person passed away, which requires a lot of judgment, consistency, and documentation. So it's a full-time job.
Yeah. And, a lot of people have sent us articles, should I have a trust? Shouldn't I have a trust? Again, it's a case by case situation and family by family, certainly. And when they can actually add value and make sense for people, because there are costs and everything also and complexity associated with them. And yeah, trust can be very useful, but we do not want people walking away thinking every family needs one because that's certainly not the case. And I think the better question is to think about it as what problem is the trust going to solve for the family or for yourself, right? Is it about controlling timing of distributions? Is it about protecting the children or even the grandchildren? Is it about supporting beneficiary with a disability, manage a blending family, preserving privacy even, or creating that, continuity? So Samantha, I think this is a good place to bring you in on where do trusts genuinely add value and where do families need to be careful about cost, complexity, and trustee responsibilities.
Yeah, thanks, Brianne. And as you said, I think really trusts genuinely add value where there's a clear purpose. So they're especially useful for minor beneficiaries, beneficiaries with vulnerabilities, blended family situations, long-term wealth preservation, and circumstances where control, protection, or timing are more important than outright access to capital. So they're also valuable when the family wants the wealth to be managed across generations in a sort of a structured way rather than transferred all at once. So a good example of this, and a very common example these days, is when you have a blended family, and you might wish to ensure that a surviving spouse is sort of financially secure during their lifetime, but you want to preserve the capital for the children from the previous marriage. I see this all the time. So a trust can be a very effective tool in that context because it can create both support and boundaries. And without that structure, the family may be left relying on assumptions that are difficult to enforce later and then just create conflict where there didn't need to be any conflict.
And Alexandra, from the legal side, how should families think about trust planning without overcomplicating things?
So as we mentioned, it's extremely important to have a clear purpose for those trusts. that probably go beyond just the desire to minimize probate fees or any sort of probate tax. It's really important to have the use of straightforward distributions, and understanding exactly when each beneficiary will be entitled to a certain asset. It's very important to clearly define who benefits from those assets and who the contingent beneficiaries are going to be. We should avoid unnecessary conditions or restrictions unless there's a specific purpose, and keep those administration requirements manageable as well.
And insurance and liquidity. Insurance is another area where we think alignment matters. We use this a lot because it's not just about risk protection. For some families, it is about income replacement and making sure if someone passes that the family's still looked after. But when you get to a certain level of wealth, you can self-insure that risk when you have enough assets. So, but in estate planning, insurance can help create liquidity, fund tax and estate costs, avoid forced asset sales. It can equalize inheritances where one child is receiving a business or real estate and the other is receiving assets. So there's a lot of benefit that insurance can provide on that front.
Yeah, and I think the question, John, that we often get asked is, where does the cash come from, right? Because taxes, probate, legal fees, accounting, corporate planning, administration costs can all arrive at the same time. Samantha, what happens when the estate does not have enough liquidity?
So this is a real significant challenge when it comes to estate administration. So a family may be very wealthy on paper, but if most of that wealth is tied up in, private corporations, real estate, or illiquid investments, for example, the executor can still face serious sort of cash flow problems. So taxes and administration costs generally need to be paid in cash, unfortunately. So if there's not enough liquidity, the executor may be forced to sell assets quickly at, not an optimal price, borrow or delay distributions while all trying to manage their sort of obligations prudently. So a classic example of this is if an estate is holding valuable real estate and shares of a successful private company, but has sort of very little cash. So the family may assume that there is more than enough wealth to pay the bills, but if the company cannot easily distribute funds and a property cannot be sold promptly without affecting the value, the executor may be under immediate pressure. And in some situations, beneficiaries are asking for distributions at the same time. And of course, those can be family members. So there's that added level of complexity. And so the executor is trying to preserve liquidity to meet tax obligations, but this can create tension really, really quickly. So I actually find like liquidity planning is quite like undervalued in estate planning, but families may spend sort of substantial time deciding sort of who receives which asset, maybe not enough time addressing how the estate will actually fund the obligations that arise when they pass away.
And so on that front, Alexandra, how should liquidity be considered when the legal plan is being drafted?
For sure. So again, through the mechanisms such as like any sort of life insurance, having those in place, but also not just on the individual side, but also on the corporate side. So if, for instance, you have those shareholders and one passes away, you want to make sure that there's enough funds to buy out that individual's share so that you don't have unplanned for shareholders on those corporations. So that's one way on the corporate side to be doing so, but that can also be done on the personal side. You can also look at things such as your designated beneficiaries and looking at how that's going to be paid out, and just making sure that there's a general plan in place that makes sense for each individual to ensure that there's enough cash in there so that your beneficiaries or your executors are not on the hook for those funds until they can be reimbursed.
Yeah, and we have a few more questions left before we wrap this up, but this does bring us back to really the main idea of the evening tonight is alignment, right? And the question is not only do we have a plan, the better question is, will the plan that's in place work the way you intend it to when it actually matters?
And that means looking at legal documents, tax outcomes, projections, how the corporate structure actually is now, and whether it's been changed through estate freezes and that. Asset ownership, beneficiary designations should be reviewed, your trust structure, insurance, executor readiness, liquidity, family intentions, and of course, investment strategy. So when those pieces align, the plan is far more likely to do what the family intended.
Yeah. So Samantha, if a family wanted to, pressure test, let's say, their plan, where would you suggest they start?
So I think there's three main things they should start looking at. So first, review how your assets are actually owned. So families should compare their will and trust planning against how their assets are actually like titled and designated. So if the plan assumes that the estate controls certain assets, but those assets are registered jointly or passed by way of beneficiary designation, the administration might unfold quite differently than it was intended. So like a family might believe that their estate will divide equally amongst their children under the will, but if one significant account or property passes outside the estate to only one child, the actual economic result may be far from equal. Second, I would suggest reviewing liquidity. So families should ask whether there's enough accessible liquidity to pay taxes, debts, and administrative costs without forcing rushed sales or sort of encouraging intrafamily conflict. So an estate may appear substantial because there's holds several pieces of real estate, but if those properties are difficult to sell quickly or they're occupied by family members, for example, the estate may still face a practical cash shortage. And third, I would just say review the people that you've appointed. So try and sort of honestly assess whether the proposed executor or trustee has the time, the temperament, the skill, and the willingness to do the job. So the right person for a modest estate, for example, may not be the right person for a complex multi-year administration. So a common issue is naming sort of the most responsible child without considering that the role might put them in direct conflict with their siblings or require them to manage a company or impose sort of long-term trust administration burdens that they never expected. So I think just making sure you have sort of an aligned plan. You're looking at like the documents in place, the asset structure, tax burden, liquidity, and sort of fiduciary appointments and how those all work together.
And Alexandra, same question from the legal side. What should people take away and revisit with their legal team and their professional advisors?
For sure. I echo everything that Samantha just said, but I think generally as well, it's looking at everything from a big picture and looking at all of your estates, all of your assets, and just making sure that all of that is encompassed within your estate plan. So that's making sure that whether if you're let's say your estate is worth $1 million, making sure you're not giving 2 million to charity and leaving nothing for your children. It's just important to make sure that all of that is considered, all of your estate is considered to making sure it makes sense.
Yeah, and I think, to wrap up, we would encourage, everyone to think about a few practical next steps. One thing we certainly review with all of our families, high net worth, ultra high net worth families, is looking at, every review is, yes, we have your wills on file, we have your beneficiary designations, but if something has changed in your circumstance or your family dynamic or something else, please notify us so we can talk about your options, what that changes can look like for you and for the family. So certainly confirming and reviewing beneficiary designations match your wishes and the will, pressure test the executor and trustee readiness, revisiting corporate trust and insurance structures. Again, we do this, but if there needs to be changes, certainly something to review, confirm where liquidity will come from down the road. And most importantly, really make sure, everyone are not working in silos. And I think that is something we do very well at, Velocity Investment Partners, is making sure that we act as your family CFO, ensuring all your moving pieces are working collaboratively.
And estate planning is not only about transferring assets, it's about protecting the family wealth. That's a big challenge that we help families with, and making decisions easier for the people who may one day have to actually act for you.
Yeah, so thank you again for being here. Thank you, Samantha and Alexandra, for sharing your expertise and your insight. And hopefully, everyone attending this call this evening learned a thing or two. If there's any questions about anything we talked about, feel free to reach out. And if it is helpful, we are always happy to walk through your personalized plan that is custom tailored to you and your family and help bring the right people to the table. Thank you.
Thank you.